I wanted to chat about transitional and savings provisions and the differences between them. So, one area of bill drafting is the use of what we call transitional and then savings provisions. So, what are their differences and how are they used? Well, I've gotten some helpful guidance for bill drafters from the folks teaching in the graduate diploma in legislative drafting from uh, Athabasca University in Alberta, Canada. They explain that all transitional provisions come into play when new legislation amends or repeals existing law. For example, a transitional provision may address the issue of how activities or rights that had begun under existing law are treated when it comes to the amended or repealed law. This is obviously important so that those who have relied upon existing law understand their rights or obligations or status going forward after the law has been amended or repealed. So basically, transitional provisions contain rules to ensure an appropriate transition from the prior law to the new law. Now, savings provisions are, some consider a type of transitional provision, and they're generally used to retain an existing or vested right or authority that might otherwise be affected by the new law. In essence, the goal of the savings provision is to preserve the right or the authority despite the new law's amendment or a repeal of the former law. So you might need a transitional provision in one of these instances. For example, does the new law apply to cases or conduct that began under a former statute? Are there interim rules to be established for folks to follow when transitioning from the former law to the new law? Are there existing rights that need to be preserved under the new law or the repealed law? Are matters under the former law to be treated differently or the same under the new law? How are pending legal proceedings, how are they to be conducted under the former law versus the new law? Should there be a new procedure or process that will be applied to existing claims? Do we develop some sort of a phase-in period? So this obviously poses the question as to how the bill drafter is going to handle these transitional provisions. And the drafter needs to use express terms in these particular instances. For example, if the new law is intended to apply retroactively, then the bill drafter should be explicit in stating this, rather than having the need to rely upon extrinsic aids or some other means to rebut the general presumption against a statute applying retroactively. Here are some examples of statutes that may require a transitional provision: the elimination of a state office and appointees to that office, legal proceedings that have already commenced but have not been concluded, licenses that have been issued and remain in force, financial benefits, perhaps tax incentives that have been earned but not yet used, the authority to impose a penalty for an offense that was committed prior to the law's amendment or repeal, carrying out duties that were required at the time the statute was repealed, legal documents that were in effect at the time of the statute's repeal. So what are some options available to the bill drafter to address these types of statutes that need transitional provisions? For example, legal proceedings could be allowed to continue under the old statute or perhaps under the new statute. The bill drafter could apply the new law to existing cases that began under the former law but have not concluded at the time of the repealed statute. In other instances, the assets or liabilities or functions or even the personnel could be transitioned over to a new entity, for example. In other instances, maybe interim arrangements are adopted in which a temporary statutory regime is utilized so that during that specified interim time period, the old rules would be used and are applicable until the new law takes effect. Regardless of the form that these transitional provisions take, the bill drafter needs to expressly deal with past matters or apply the new law to the current circumstances only. And the drafter should strive to provide a smooth transition for those who are affected by the old law or regulated by the old law, as well as those who are impacted by the new law.